Yep.
Okay, welcome to the Judiciary Committee this Tuesday afternoon, January 16th. This afternoon, we are going to be looking at H 645, a number of witnesses. I do believe we do have Tom Burdick online?
Not yet.
Not yet, but that's fine. We can probably proceed anyway. So we will, from 1 to 3 with a break somewhere in there, we'll be hearing about H 645. And just for folks to know, H 780 is, we're going to get a walkthrough on that bill relating to judicial nominations and appointments. But we'll start with Professor Bobby Sand. Thank you so much for being here virtually, but it's nice to see you. And we'll turn it over to you.
Thank you so much. For the record, Robert Sand, Bobby is fine. I'm a professor at Vermont Law Graduate School, the founding director of its Center for Justice Reform that includes a Master of Arts in Restorative Justice and a professional certificate in restorative justice. I'm partially funded as well through the National Center on Restorative Justice, which is a partnership between Vermont Law Graduate School, University of Vermont, and the University of San Diego, funded by the Bureau of Justice Assistance. And I'm the former Windsor County State's Attorney. And everything I'm about to say is my opinion and not necessarily that of any of my employers. And I'm sorry I can't be there in person, but perhaps not too sorry. I'm in Savannah, Georgia, and it is not snowing, sleeting, or otherwise horrible where I am right now.
Or we can't be with you.
Thank you for this opportunity. I wanted to start with a reflection, perhaps an observation. That is, when I went to law school, it was emphasized that courts and judges were really the most powerful actors in the criminal justice system. And then, I don't know, maybe 10 years ago, people really started appreciating the power and discretion of prosecutors and started saying, well, prosecutors are the most powerful actors in the criminal justice system. And I have come to believe that both of those things are not correct. I really believe that legislators and the legislative branch is the most powerful actor in the system. You folks created, modified, or inherited a system, and you all have the power to change it. And so if you're happy with it, leave it as be. If there are things that need to be changed, I hope you will do that. I want to echo something that Willa Farrell and Rachel Jolly each said, and that was that restorative justice is a philosophy, not simply a response to low-end offenses. And I think that is absolutely correct. I believe that a restorative response is possible for all harm, for all crimes. That does not mean all offenses go to diversion or pre-charge, but a restorative inquiry is appropriate regardless of the nature of the harm. And hopefully I can demonstrate that. So RJ asks a different set of questions than we traditionally ask. RJ asks, who was harmed and what do they want and need? Who's responsible for causing the harm? And then more broadly, what systems or structures contributed to the harm? What obligations does the responsible party have to make amends? How can the responsible party be responsible by making amends? And then how can the overall response, to the maximum extent possible, consistent with public safety, lead to a strengthening of individuals, of relationships, of community? I don't think there's any harm for which those 4 questions don't apply. And while I recognize that the legislature may put limitations on what kinds of cases can go to diversion or not, I hope you will come to appreciate that thinking about responding to harm through a restorative lens can apply across the board. It's important to note that that final question included the phrase, to the maximum extent possible with public safety. Incarceration and a restorative response are not inherently contradictory. And even Howard Zehr, the kind of grandparent of the contemporary RJ movement, recognizes that. There are people who pose a present and ongoing risk of harm, and separation from society may be necessary. Okay, let me talk about the current statutory scheme. I'm reminded of the expression that a camel is a horse built by committee. I think Chair Emmons used the phrase hodgepodge, and then Derek Miodovnik has analogized it to an old barn with lots of additions. And I really like Derek's metaphor. My daughter works for the Vermont Youth Conservation Corps in Richmond, Vermont, and they are undertaking this massive barn renovation project. You can see it as you're driving down 89. There's some pain involved. There's a lot of physical labor, and they're not entirely sure how they're going to use it after it's done, but they know it needs a new foundation and new structure. And I think the same is true for our RJ laws. We need a new foundation. We need a new structure, even if we don't exactly know how all the pieces will ultimately fit into place. I've had the benefit of listening to some of the prior testimony, and I think your witnesses have really hit on important points. It pains me to say this, but I think Chief Judge Zone really highlighted some of the points that needed to be made. I want to just address a few of those, if I might. That was a joke, by the way. I go back a long way with Judge Zone. So first, just structurally, this bill creates a delineation between pre-adjudication matters and post-adjudication matters. And that is just logical, makes perfect sense, and is, I believe, the right place to draw that distinction. The issue of confidentiality has come up. The bill is introduced, talks about confidentiality across the board, but in other places it talks about confidentiality for the present matter. And so coming up with a consistent approach to confidentiality is important. Blanket confidentiality may be going too far. If someone discloses an intent to cause substantial harm to another, I don't think we can expect or would want to expect that the recipient of that information would simply sit on it. So limiting or constraining the confidentiality to matters related to why the case has been referred probably makes some sense. Judge Zone talked about, and I recognize I'm jumping around a little bit, expungement and the current provision in law that talks about judges making a finding that expungement is in the interest of justice. And he intimated that maybe you could scratch that. And that is a provision that honestly does not make sense. Judges, when a person completes the restorative process successfully, there shouldn't need to be a further independent finding by a judge. And the reality is they're not engaging in a separate inquiry. So I think striking it makes perfect sense. We come now to a subject near and dear to my heart, and that is the right to counsel. And Judge Zone mentioned that under current Vermont law, a person charged with a misdemeanor where the judge says on the record, no probation, no jail, and no fine over $1,000, indigent people do not get the benefit of the public defender. And so I hope the legislature will ask itself, do we want a system where indigent people are effectively compelled to represent themselves in criminal matters? I think the answer to that ought to be no. If something is a crime, it is a serious matter inherently, and the services of a public defender should apply. I recognize that they are burdened. I recognize that there's a backlog. I also recognize that there are some dates in this bill that don't kick in for about a year, and perhaps that creates an opportunity for more universal access to public defender services. I recognize this committee over the years, I think twice, has amended the public defender statute, and the other body hasn't taken that up. This bill may provide further opportunity. I do think that individuals referred to diversion need the ability to speak with counsel. And for those people who are referred or indigent, if there isn't public defender representation or some other similar way to speak with an attorney, they are put at a disadvantage as compared to people of means, and that's not justice. The issue of backlog has come up quite a bit, both in this legislation and in other matters. And yes, we need to dispose of more cases, but we also need to figure out, how do we stop sending as many cases into the court system? And this bill certainly does that. I want to emphasize that not only will this cut down on the number of cases that are filed, but it will also help achieve relational justice, which I think is a different thing than procedural justice. And the court system is outstanding at ensuring procedural justice, but maybe not as good at relational justice. Couple more comments and then I will stop blabbing. Ensuring that there's an opportunity to speak with counsel is also going to help safeguard against net widening. I will tell you, not proud of it, but as state's attorney, there were cases that I looked at that were less than stellar cases, cases that in all likelihood I would not take to trial, but I filed it, and filed it with the attitude, let's see what happens. That's not a good way to do business. I could do that and recommend a fine only and know that the public defender would not look at the case. And I just think that that's an inappropriate practice. I suspect I was not alone in doing that. Having the inquiring eyes of defense attorneys will be a way to help safeguard against net widening. As I read the bill, the state's attorney retains the absolute discretion to pull a case back if it has been referred to diversion. I know there's been some talk about intruding on prosecutorial discretion, and I don't see that. I think it is preserved through this legislation. We have an obligation to move toward geographic justice. And if individual departments aren't policing themselves to ensure a more consistent approach statewide, then I think it falls on the legislature to help ensure that we achieve or at least get closer to geographic justice. We're supposed to have a system, not 14 or maybe 15 different systems. And so I do think it is appropriate for oversight from this committee. When I started out, prosecutors' offices were funded based upon the number of cases they filed. That meant the number of deputy state's attorneys they would get was based upon how many cases they filed in court. That is, I won't use the expression that I was inclined to use. That is not a good way to do business. In fact, I think we should flip it. And I think we should say those counties that utilize community-based resources the most should receive funding to hire a community-based prosecutor. And even if we don't go that far, we certainly shouldn't be funding based upon filings. And I don't know if that's still the case. And I know you have a representative of the department speaking later, and maybe they can weigh in. But it is a huge savings to the judiciary and to the system to have robust diversion programs. And those prosecutors who are utilizing those programs, I think, should be recognized in some capacity. And with that, I think I've said what I wanted to say, but I'd be happy to answer any questions if there are any.
Barbara.
Good to see you. Thank you for your testimony. So I'm wondering if you think the bill, the way it is written now, would accomplish our goal of moving to geographic justice in terms of how it's worded for individual state attorney offices and following the policy and having the discretion to, as you said, pull a case or not refer a case. Is it strong? Is that strong enough?
Honest answer is I need to dive back in. So we've been on the road for 5 days. And so the provisions related to MOUs and agreements, I think before weighing in on whether they are sufficiently strong or not, in fairness to you all and to me, I think I'd like to go back and look at that. What I honestly really focused on was the structure of which cases go where based upon whether there's been an adjudication or not.
Fair enough. It's just a concern that I had. And when you raised it, I was like, oh, this is great. I can ask you. I have one other question, which is, if we were to, well, I have 2 questions, I guess, when I'm looking back at my notes. You talk about limiting confidentiality to the matters of why the case is referred, which is great. And I think that makes sense. I'm curious though, because that's easier said than done in some cases, right? Like sometimes a case is referred and it's like when you get into the heart of it, it might be because I wanted to hurt. I mean, so it could end up bringing up the kind of situation that you were saying doesn't make sense to keep confidential. So I just wondered if you had thoughts about how to thread the confidentiality needle.
So I can't remember offhand what the current diversion language is, but I think the current diversion statute talks about confidentiality related to the present matter. And that seems to have worked all right. And so I acknowledge that is imprecise, but it seems to have worked all right so far. So that may be the answer. And I should say, and I've said this to this committee before, are there going to be some bad outcomes? Yeah, there'll be some bad outcomes because we're talking about fallible human beings. And that shouldn't be the measure of the success or failure of this legislation. Sorry, get another question.
So my last question is, in terms of having a system of restorative justice, do we need to do more system-wide training of people? I'm assuming there's very specific training for judges, for prosecutors, for what? So I'm wondering where might attention to setting people up to have success with making referrals as, as optimum as possible.
What I can tell you is that as a prosecutor who did not know a lot about restorative justice, I knew that diversion was a way that I could move a case off of my docket and not have to worry about it. But honestly, I didn't have any idea what was going on. I should have mentioned, I have for the past 2 years, I've been volunteering at a justice center. So I have a much better sense about how RJ is implemented in Vermont. Why am I completely blanking on your question? I'm sorry.
It's just like
No.
where does training need to occur? Yeah. And I mean, maybe it's also at the law enforcement level. I mean, so I'm wondering in the optimum use of restorative justice, where do we train? Yeah.
My only partially flippant response is that everyone should earn a professional certificate in restorative justice from Vermont Law Graduate School. We actually have a annual cohort of DCF employees or contractors who come through our program. There's some federally funding that helps with that. But I think the police academy would be an excellent place. State's attorneys have an annual conference. That would be an excellent place. I know lots of folks who'd love to lead some restorative circles for legislators. So yes, I absolutely agree, because there is this notion that, and I'll echo what Governor's Council said, echoing what she perceived the public perception was, that it's all carrots, no sticks, that this is an insignificant response. And the reality is, it's a whole lot harder to come to terms with your own harmful behavior than it is to go to court, deny, say nothing, and then make a performative apology in the hope that your sentence will be lessened. RJ is a lot of work. It's really hard. And I think the more that the actors understand that, and the more that the public appreciates that, the more we will see RJ used. And someday, in my ideal world, RJ becomes the default response and court becomes the off-ramp. So we talk about the sequential intercept model. I built an entire course around the sequential intercept model, suggesting that there were off-ramps to the court system. I'd like to see RJ as the predominant highway, and if need be, there's an off-ramp to go to court. But the main thoroughfare is a restorative thoroughfare.
Thank you. That's helpful.
Okay.
Yes, thank you for being here and sharing. I feel like you have a really unique perspective with the understanding of restorative justice, and also your time at, and you said it was Wyndham State's Attorney? Windsor State's Attorney. Apologize. And so when you were State's Attorney in Windsor, I believe you did not have a pre-charge referral program. Is that correct?
Essentially, yes. One department wanted to start one. I signed off on it and then discovered that all the athletes were going to pre-charge and all the, quote, bad kids were being sent to court, and I shut that down.
Okay. That's helpful. That helps to get at my question, because one of the, on the other side, the opposition of this is that there's the possibility, let's just have each county set up their own pre-charge. We have some counties that already have established in sites. And so I'm wondering if you can speak to the pros and cons of that approach versus a statewide approach, because I think like your example that you just shared gets to some of where around consistency, reliability, that kind of stuff. If you can speak to that, I feel like that would be helpful.
I like the idea that the county is a mini laboratory and can innovate and create some new approaches within a statewide structure. I don't think it should just be carte blanche for every state's attorney to decide, yes, I want to do this, or no, I don't want to do this. It's a system, and it's a system that you all have created. Personally, I think a way to do it would be, as I mentioned, to incentivize the use of free charge programs. Exactly how you do that, I mean, we could talk about that, but I think it is reasonable for the legislature to say, we have an expectation that in each and every county of this state, there will be diversion referrals. And I think it's appropriate for the department to report on the extent to which the counties either mirror each other or diverge based on their use of pre-charge or diversion, which under the bill will all fall under the umbrella of diversion. So I suppose, Representative Dolan, I'm somewhat hedging my answer to say some latitude is appropriate, but if it's to be a system, it cannot be carte blanche for all 14 counties.
Thank you.
Thank you. Thanks again for being here. I wanted to just get a little bit more clarity about the confidentiality issue, because I think, because this has come up a few times, and I'm noticing that in our under confidentiality, so I'm on page 30, right at the top, subsection 1, the matter shall become confidential when notice of a pre-charge referral is provided to the diversion program or notice of post-charge, et cetera, et cetera. What is that, Willy Wonka? Et cetera, et cetera. And then under rights and responsibilities on page 33, we have the language that says information related to the present offense that is divulged during the adult diversion program shall not be used against the person in the person's criminal case for any purpose. So do those two things seem at odds to you, or does having it in rights and responsibilities cover the concern that you brought up?
You are highlighting exactly the discrepancy that I was trying to note, that there seem to be two different provisions that don't have the same language.
Right.
And that's probably not helpful. And so the language, information related to the present offense, is probably the preferred language, at least in my judgment, because it doesn't create essentially absolute immunity for anything and everything, which I think would create some possible public safety risks.
Okay.
So is that responsive?
Yep. Thank you.
Sure. Oh, no, go ahead. If you had
There's one more thing that I forgot to mention, and that relates to the fees for participating. And in my perfect world, no one would be charged a fee to go to diversion. It's not a perfect world. I understand that. I do not understand a differential fee structure for pre-charge referrals versus post-charge referrals. And it seems to me that is potentially creating an incentive to file a case in court, because then when it goes to diversion, the fee is greater. And so I hope you'll consider a uniform fee structure.
Wait. Karen?
Yes, wondering if you can speak more to the, you shared a bit about this, about the discretion piece. I feel like that's another issue that keeps coming up. And so if you can just share more of why you believe how the language is not taking away discretion from the state's attorneys.
I know as when I was a state's attorney, I had the unreviewable discretion to pull a case back that had been sent to diversion. It was my decision that keeping the case in diversion was a mistake. I don't see anything in this bill that removes that discretion from prosecutors. And so even if there are presumptive cases to go to diversion, the prosecutor still retains, as I read the bill, the unreviewable discretion to decide this particular case is not appropriate for diversion. So their discretion is preserved.
So following up on that a little bit further, I mean, where I find where we are maybe going into their discretion is everywhere that I see the word shall. And I understand that entities, and particularly state's attorneys, don't like to be told what to do. Even though we do set statutes and limitations, we do set penalties, we do have minimum penalties, even certain misguided offenses. So we do that a lot. But so putting that aside, because I think I might have a slightly different viewpoint of how unfettered the discretion is of state's attorneys, but I will respect that they have a lot of discretion. And I think where we have a lot of the shells is with respect to that they shall form a uniform policy, that each state's attorney's office shall put one in place, that the Department of State's Attorneys, along with the Attorney General's office, the Community Justice Unit, shall review those individual state attorneys and shall require them to use the uniform policy if that review is not satisfactory, that they are following the uniform. So that's where I see where we're perhaps getting into their discretion, because I do understand definitely, we're saying these are qualified crimes. That just means that these are the ones that go there, but you are going to decide, state's attorney, who's eligible. That's a little bit different. So repeat offenders, they may decide that that they're not immediately presumptively eligible and they have to do something special. That's all in the policy. We're letting them figure that out. But that's kind of where trying to navigate the discretion that state's attorneys have and our desire to have some continuity and consistency in dealing with geographic justice. Do you have any input on that? And then I have a follow-up question as well.
Prosecutorial discretion is not absolute in all matters. And I don't see that it is an intrusion for the legislature to say you shall develop a policy, particularly where the ultimate decision for any individual case still rests with the state's attorney. And the reality is, you folks are orchestrating the funding for the department. And I think that gives you certain abilities to say, here's our expectation that statewide, every county will have a policy. And so I don't see that as an intrusion in the decision-making process. That's the part that is virtually unreviewable. A decision to charge, a decision to offer a negotiated resolution, plea agreement. the decision to make about what sentence to ask for. But for the funding entity to say to the recipient of those funds, we want to see a policy, I simply don't think that that's an intrusion on prosecutorial discretion. And the reality is, and not to make life more complicated than it needs to be, you could flip it, work with appropriations and say, no office gets funded unless and until it has a policy. And then it's completely their choice. I mean, honestly, I know there was some issue about a sheriff and should there be an impeachment. And I thought the easier way to do it is say there shall be no funding unless the elected sheriff is certified. So I'm sorry to sort of go far afield, but
Are you trying to give me advice on that other part of what I'm doing here? Is that
that was not intended as a subtle signal, but I mean, there are absolutely ways that you could structure this such that the state's attorney decides they aren't going to do it, but there are consequences for that. And I just don't see that as intruding on the core discretion of prosecutors.
So we do hold the purse, which is a fun place to be, I suppose, unless the purse is running dry, but we'll put that aside. But so let me ask then an overall philosophical question on the approach. And I'll go ahead and say I already like our approach here. But so one approach could be, let's instead really make sure the diversion has the resources. Let's start with the CJCs and the diversion unit and give them all the resources so they're ready to take more pre-charge. Because we do get, we do hear in some counties that, maybe its state's attorney actually wants to do pre-charge, but they can't because there's not the funds. Well, maybe we just go and find out and provide the funds, and then this will all follow. As opposed to what we're doing here, which is, I think we're building the structure so that the funds can follow, so that there's more likelihood, I think I can convince appropriations as this builds that they will fund this because we have the structure in place. I guess I answered my question, but I wouldn't mind you weighing in on that.
So refurbishing this barn will happen in stages. And what you're suggesting is, I think, that maybe some of those shalls can be held in abeyance to allow the pre-charge programs to develop. And that's not an unreasonable approach. What we do know, though, we have a track record that certain counties utilize diversion in vastly different ways than other counties. I know the last time I looked, Windsor County, 50% of the misdemeanors were going to diversion, and in other counties it was single digits. So to the extent that you folks are the guardians of the system as a whole, I think the day will come, even when diversion is fully and adequately funded, where you'll want to say, we are not achieving geographic justice. This is not a system. We, the legislature, need to step in to make sure our system is more equitable in all parts of the state.
So one last question I have is, you mentioned incentivizing the pre-charge programs. And do you have more ideas of what that looks like?
Well, as my op-ed in Digger commented, money is a powerful incentive. And so it is absolutely backwards to say state's attorney's offices get funded based upon the number of charges they file. That just creates a perverse incentive to file cases. I don't know that that's still how they fund. You absolutely have witnesses who will be able to talk about that. But why doesn't each office have a community justice prosecutor? I don't want to step on Aaron Jacobson's toes or Willa Farrell's toes, but it's just as reasonable to me to say that offices that robustly use diversion, offices that save the judiciary a lot of money by not filing cases, will receive some benefit in the form perhaps of personnel to further develop their restorative responses.
Right. And you mentioned community-based prosecutor. Can you describe that position a little bit further?
Yeah, sure. So way back when I effectively embedded a prosecutor in a town that had lots of issues, and I didn't do it particularly well, but there are community-based prosecutors in this country, and they work to try to address and solve problems at the local level before they ever get sent up to a state's attorney. And so perfectly reasonable to envision a prosecutor, a state's attorney's community liaison, maybe not even necessarily an attorney, but someone representing the office based in community, helping to address disputes. We have outsourced all of our responses to harm, right? So Windsor County, largest geographic county in the state, everything gets, excuse me, sent up to White River, separate and apart and distant from where the harm occurred and from the people who were harmed. So to some extent, I do think we need to go back to the future and look more at the community level. How can we resolve disputes? And having a representative from the prosecutor's office based in community might be one way to do that.
Karen.
Yeah, I don't know if this is an appropriate question, but curious to get your thoughts if you're willing to share them. So pre-charge, all these forums that we're talking about for restorative exist in Vermont already. One of the goals of this is just to make it statewide available. What are your thoughts on Vermont's capacity to do this? Are we at a point where we have the capacity to make this happen, pre-charge across the state?
I have said this before in other contexts. The best way to know our capacity and our deficiencies is to do it. If we spend lots of time inventorying, we're just going to tread water. So I think the way to do it, build this structure. I promise you will hear if there are places that don't have the resources to address the capacity issues. But I think it's backwards to build infrastructure in the counties without the framework of this bill. This bill is the foundation. Those other pieces will fall into place.
Any other questions? I don't see any. Thank you so much for your time. And as this goes through the process, you may be getting a holler again to weigh in on language as it's being modified.
Happy to be involved, and I'm going to turn off my camera and listen in some more.
Great, thank you.
Thank you.
We'll turn to Derek next. And Derek, I've mispronounced your last name sometimes. So if you could pronounce it for me, and then I will properly ask you to come to the
Miodovnik.
Miodovnik. We now have Derek Miodovnik. Thank you very much for the slow pronunciation. I promise I won't mess it up again.
My pleasure, Joe. Thank you for the care. For the record, Derek Miodovnik. Community and Restorative Justice Executive with Vermont Department of Corrections. And I'm going to grab my water too. Thank you.
So I understand you're mainly giving us some input, I believe, as I understand, on the part that's the Department of Corrections component post adjudication, which is almost entirely being handled down the hall in corrections, but we wanted to hear your view on that and your view on how pre-charge has been working within the Department of Corrections for the last several years. So did I get all that right, Karen? Is that thank you.
So I'd like to just start by making some opening remarks. But to your question or to your understanding, Chair Lalonde, yeah, my intent here is to reflect primarily on the intersectional points between the current operations through the Department of Corrections of the post-adjudication restorative process. Reflect on where and how we hope to actually expand the use of restorative justice principles and practices deeper into the populations that the Department of Corrections directly serves. So thank you, Chair Lalonde and Representatives Dolan and Arsenault for all the thoughtful work that you've put into this bill to get it to this point. And thank you to all the members of House Judiciary Committee, as well as Chair Emmons and the House Institutions and Corrections Committee for your vital role in this important piece of legislation. I also want to take a moment to acknowledge the care and expertise that has already been shared by my colleagues during the presentations connected to the initial walkthrough of the bill and through the testimony that has already been provided to date. Restorative processes invite us to not only share our own stories, but to lean into others as well, often creating empathy in the process. To this end, I hold a special appreciation for Legislative Counsel Ben Novogrodsky. And I'm grateful in particular that I do not have his job. I say this first and foremost to recognize his seemingly tireless efforts in iterating this piece of legislation, so thank you. Okay. And secondly, to frame some of my subsequent testimony. The farmhouse analogy, right, seems to resonate for how we've iterated Vermont's restorative justice infrastructure. My colleague Eric Jacobson's reference last Friday to constantly being under construction, right, also speaks to the evolving nature of how we collectively pursue justice here in Vermont. In his seminal work that Bobby Sand also referenced, Changing Lenses by Howard Zehr, Zehr describes justice as a paradigm, and indeed we've heard that earlier from Willa and other colleagues, including Rachel Jolly. And he goes on to describe how our institutional approaches are built off and become dependent on a particular understanding, i.e. paradigm. And then he goes on to write, quote, dysfunctions begin to develop as more and more phenomena do not fit the paradigm. However, we keep trying to rescue the model by inventing epicycles, reforms, which piece it together. Eventually, though, the sense of dysfunction becomes so great that the model breaks down and is replaced by another. This cannot happen, however, before a new, quote, physics, end quote, is developed. That is, a variety of building blocks must be in place before a new synthesis is possible and a new common sense emerges. I say that by way of acknowledging that I see this bill in broad strokes as an attempt to put into place a new building block toward adopting a restorative paradigm for justice in Vermont. And in my role as Community and Restorative Justice Executive, I applaud that spirit and intent. I also see it as consistent with the vision that's been set forth in Title 28, 2A. Of course, that's the correction statute, but it reads in part, and I paraphrase it, it's the policy of this state that principles of restorative justice be included in shaping how the criminal justice system responds to persons charged with or convicted of criminal offenses. The policy goal is a community response to a person's wrongdoing at its earliest onset and a type and intensity of sanction tailored to each instance of wrongdoing. So that is, I think, the broader framework through which I want to once again recognize the intent and the challenges inherent in making updates to this farmhouse, if you will. And it's a complex piece, and the bill has a post-adjudication piece to it and a pre-adjudication. And I think it's worth noting that even the post-adjudication content of this bill primarily concerns corrections in its role as an administrator of grant-funded programs. It's not particularly concerned with our role within our primary functional identity, if you will, as a supervising agency of individuals who, are on any number of convicted statuses, right? That's not concerned with supervision per se, although I imagine the model policy will contemplate some of that interaction. I mention that because that calls into question, and I don't mean that in a critical or a skeptical way, but in a literal way, multiple points of intersection between the agency of administration bulletins, 3.5 and 5 in particular, which govern procurement and grant management and monitoring and evaluation. And so as I did multiple read-throughs of this, some of the overarching questions that I found myself sitting, and some of which I'll pose to the committee as we walk through it, are in recognition of the spirit and intent, and just flag some questions that I think might require some further administrative clarification in the post-adjudication sense or space. I'll pause there and just see if there's any immediate questions around anything I've laid out so far.
I don't see that yet, so.
Okay, thank you for bearing with that. Changing lenses, by the way, reference that. I'm going to remove my mint now, excuse me. I will just stick it in my pocket too. So if folks haven't, I really highly recommend familiarizing yourself, at least with the chapter called Justice as Paradigm, from which I read an excerpt. If I were to recommend a reading, I think it's an important piece. So to the bill at hand, my primary goal is to, as I confirmed, speak to an intersection between the existing primarily post-adjudication legislation here and the current operating structure, which is in place. And I think that that's an important thing to realize. Standing back a bunch of paces, much of what is contemplated in the back part of this bill, beginning on page 52, essentially, is already more or less, in place, both operationally and administratively. And I think one of the larger functional changes that this makes is it would have the impact of better titrating or refining the scope of work through the DOC grants to the population that statutorily we provide services to, i.e. those who've been adjudicated and convicted. And so that work already certainly takes place through grants that are managed and administrated by the Department of Corrections and go to community-based providers. We have some vernacular around those providers that we often historically have used the language community justice centers. That brings with us its own set of complexities. And, this bill uses the language of community-based grantees, which I find instructive. Turning to the bill itself, a couple questions. Again, most of my flags for questions and or suggestions will be on the back part of it. However, an important one does stem from some language on the very first page, page 1, line 18. The sentence that begins, the bill also proposes to create a post-adjudication reparative program under the administration of Department of Corrections and in consultation with the Judiciary, governed by memoranda of understanding that are required to outline eligible offenses and so on. Two pieces I just want to flag here. The first is the verb to create. I would argue that the bill updates the post-adjudication reparative program that is already in effect. And the reason that I feel like that's important to flag is not just to parse that language for a greater accuracy, but as an administrator of state-granted funds, I would interpret create and subsequent language around the funding that happens later in the bill to require a procurement process, because in effect this says we're creating something new that hasn't existed in this way before. And then it becomes incumbent upon the Department of Corrections, as per my interpretation of Bulletin 5, to conduct a brand new procurement, i.e. RFP process, specifically for an infrastructure that is already in place. So one question is that the intent?
So let me, a couple things. I guess a question first. Do you see anything from page 52 on that suggests creating as opposed to updating?
I do see one thing that I think is subject to my that interpretation.
Okay,
I'm happy to leap over to that if that's helpful, Chair.
Yeah, and I'll just say that first, that description that you're seeing, that you're reading from, that isn't even legislative intent. That is legislative counsel's description of the bill. So it does not travel with.
Thank you for that clarification.
Which is important. But nevertheless, it's important to get our descriptions right.
Yeah, thank you for that. To answer that question and kind of, again, sort of hop over to the piece in here, but I will then sort of take us probably back a little bit after. But I do see on page 55, line 13, this is subsection 2, which speaks to providing grants of financial assistance, and such entities engaged with a similar post-adjudication program before July 1, 2024 shall be prioritized for grants of financial assistance or contracts for services. I think that language is subject to an interpretation administratively that would say we're creating a new funding opportunity and a criteria for making those funding decisions would be to prioritize those pre-existing programs.
So this is language that is probably more important in the pre-charge where we are in fact creating something new through the Attorney General's office. But it doesn't make sense for the DOC part is what I'm hearing. Am I interpreting that correctly?
Yeah, I don't want to get out of my lane and try to opine on what would make more sense in the other spaces so far as try to be precise about what I see the intersectional points between DOC's current operational framework is. I would offer again, a lot of my comments are coming really more from an administrative perspective, that the procurement process laid out on page, I believe, 12 of Bulletin 5 speaks to requests for proposals and that there's scoring criteria. And in general, a scoring criteria for any merit-based proposal includes awarding points or integrating the qualifications of the bidder or the applicant, and that naturally any organization that's already been doing aligned work with an RFP process would in fact score well. I'm not sure whether or not it's appropriate to put in legislative language that determines what kind of agencies should be prioritized. I believe the intent in part was to recognize that some of this stuff might create changes and that we've got current organizations and this and that. But if you conduct a thought exercise of fast forwarding 5 years and then see how that language or that notion holds up about entities that did this work before 2024. So I'll leave that at that. But
that's very helpful, and we'll flag that for the earlier part. And I'm sure that you'll bring this up with the corrections and institutions.
Yeah, that's a good point. That's a good point. I mean, I think in some ways it might not be as necessary for, the totality of the comments that I've prepared to walk through here, given that the House Corrections and Institutions Committee is going to be, I think, doing more of the fine-tooth comb work on this. Is that accurate?
Yeah, from page 52 on. Correct.
Okay.
But that's actually very helpful that you pointed that out, because that's relevant, obviously, to the first section as well.
I'm happy to hopefully be of service. And again, I don't want to sort of overreach beyond, our scheme. But, an interesting feature of this is that because restorative justice explicitly and implicitly derives its traction from involving the people and the parties most directly impacted by any given situation, then on a structural level, beyond the causal reasons why state sometimes procures services through grants and contracts, it's all the more critical that restorative justice be conducted in partnerships between the state and the community, right, as represented by these community-based grantees. What gets interesting is that the vehicles through which we do that, contracts and grants, are subject to all sorts of then administrative rules and policies that live in the AOA bulletins, and that do potentially raise questions about the points of intersection here. A broader example for that might be, and I won't get into the specific language, if DOC is granting to a community-based agency and the operating scheme is to have MOUs between grantees and the court and the local state's attorney, and DOC does not necessarily govern those MOUs. Our relationship is primarily governed through the legal grant we have with one provider. So these are just, I think, some of the richness that I see as a building block. This kind of the sense of this new physics that we're trying to build. I think we're going to need to embrace the fact that there's construction required, our construction mindset. I can't speak to the totality of how that all is laid forth in this bill. A couple other things that I think, though, are germane to this committee are to recognize that the current framework that we call reparative probation historically, and that this updates, once again, it does exist. It operates effectively. We have the capacity in every county within the state for individuals who have a component of their sentence to have a reparative condition met, have a provider who runs a restorative process. We used to call them reparative boards originally. We've moved to restorative panel. The particular process can shift. Some of the language in the bill, and I'll flag the first time it appears, but then it reappears. On page, I believe I saw it first on page 54, line 20, beginning on line 20. Sub 1, the commissioner shall develop and administer a post-adjudication reparative program in all counties. One question I would pose is, again, is the intent when using in all counties to indicate that the administrative locus or the administrative entity on the local or regional basis is in every county, and or that's the operational impact. For example, if that's not clear, the Department of Corrections currently has a grant with, technically the grantee is the City of St. Albans. City of St. Albans is effectively a host to the Franklin Grand Isle Restorative Justice Center. You'll notice right there in the title that you've got one grantee that in this case happens to also be a municipality providing services for a different county, Grand Isle. So we don't have any administrative relationship with the grant. So I would want to know what's intended there as we go forward with this language in order to, I would offer serving all counties would be my suggestion.
Yeah, and definitely that makes sense. And again, that actual language is something in the Department of Corrections and Institutions Committee.
Yeah.
So we will take that input back to the earlier section because I think it applies just as well there.
Yep. So yeah, I think insofar as the finer pieces as they relate to DOC are the purview of HCI. I think that I'll reserve some more of those granular questions and or suggestions and look forward to that opportunity. I do really, again, appreciate the attempts to work in service of this broader paradigm of restorative justice at a moment where we are trying to import it to a greater degree into, a dominant structure and figure out, how to do that. And Corrections is ready and willing to continue on with our work. And I'll loop back to my earlier comment by way of closing that on a functional or administrative level, if you will, a portion of the time that is monetized through our current grants to our community providers is consumed to good effect, but nonetheless consumed working on this pre-charge space. And were those resources that are currently devoted to that set of activities, and that set of activities has very different volume in different parts of the state, which of course is a big piece of what you're trying to address here. Were we be able to redirect that and build upon our restorative justice strength, we could really lean into advancing restorative justice in the correctional facilities and probably do a greater degree in the community supervision space beyond just probation. I hope that one of the outcomes of this is that the Department of Corrections is able to pursue its vision consistent with our mission of advancing restorative practices, and essentially redirect some of those resources as well as potentially build on them in service of this restorative paradigm, where we do see great impact and great outcomes that I think are consistent with the goals of both corrections and the broader legislation surrounding the criminal justice system.
So a couple questions along those lines. So do you have current plans as far as some of those other places where you could use resources, expanding the reparative and restorative justice practices within DOC?
And, I would say we're in an active ideation phase.
Okay.
I wouldn't go so far as to say plans with a capital P.
Right.
Plans are always predicated on resources.
Right.
I would say the desire and the opportunities seem really well primed at this particular point in time, pending again some of the resources and the way to move that forward, and some of this bill could potentially interact with that.
So you may not be the one who can answer this, but I'll ask the question anyway. So I've gotten informal agreements, and maybe not far enough up the chain of command for anything to be binding. But my understanding is the Department of Corrections is going ahead and doing the grants for pre-charge for this next fiscal year as we're trying to work this out. But my understanding has also been in the past that this is not something that would necessarily continue because of the other demands that the Department of Corrections has. In other words, this I'm speaking of is Department of Corrections funding the pre-charge work. Is that my understanding? Is that the thinking still? I mean, you've been very kind to go for another year, and we appreciate very much that, but that doesn't seem, from what I understand, that there's any surety that that funding stream is going to continue for pre-charge.
Yeah, respectfully, I don't feel like this is the particular opportunity to make any public statements about the administrative intent of the DOC with regards to its grants. To your point, though, the current language in what we call our Community Justice Center grants does include the pre-charge as a service, and our grants that we are currently operating are we're evaluating or reevaluating multiple aspects of that scope of work.
So and there's nothing in legislation, law, policy that requires the Department of Corrections to continue to fund pre-charge. Is that correct? I mean, that was multiple. I should break that up. Anything in legislation that requires Department of Corrections to fund pre-charge.
I don't want to, again, sort of get out beyond my legal expertise.
Okay.
I am not aware of any specific piece of legislation that requires that. Title 28 2A certainly speaks to the policy of the state, and it goes into some greater detail about using restorative justice at the earliest onset within the criminal justice system. However, interestingly, it's statutory language that currently is nested within Title 28. So, you know, those are, you know, finer conversations about intent and language.
Understood. I didn't think I'd get an answer from you necessarily.
Yeah,
On this question, but
I also just,
that.
I just do want to take one moment and publicly recognize the amazing work
Absolutely.
that our community-based providers are doing. One of the challenges of this conversation that I just want to be hopefully a little clear about and authentic about is that so much of my work, again, as I've hopefully tried to make clear, is governed by the role of corrections as an administrator and the complex intersection between the administration of grants that, you know, and then broader policy intent and funds that have come through the Department of Corrections. And sometimes when we talk about the money and which institution pays for which services right now and how that might not be an optimal alignment, I think it's easy to obscure the incredible work that is happening on the ground and be perceived as potentially insensitive to what this means for the professionals who work in these community-based agencies and the volunteers who are recruited and show up and do this. And so I think when the state speaks in purely administrative terms, we lose also potentially a bit of the nuance from the community-facing side of like what they're doing that adds such direct value back to that. And I just want to take a moment and honor that and reflect that and try to hold that simultaneously with the broader role of corrections as, again, sort of primarily an administrator in this, you know, scheme, if you will. So thank you for just like hearing.
No, we appreciate, we appreciate that, definitely.
Yeah.
Question.
My apologies if you're not the right person, but then my follow-up question is going to be, who is the right person?
Yeah.
So I appreciate this place where we're at, if we're trying to remodel the farmhouse while we are in it.
You got it.
And so I'm hearing like not at a point where you feel like you can share, this is the vision of DOC restorative programming or not. At the same time, we're trying to ensure that pre-charge is available statewide. And so some of the opposition or pushback to this has been, well, let's just keep it how it is. But I'm feeling that there isn't a guarantee that that's going to happen and that this creates a space for us to create a program, a service that we're saying all of Vermont deserves. So the AGO's office has offered to be the lead on it. Am I hearing that potentially DOC wants to could take on the pre-charge program? Because you're saying that you might not be ready to give up the funding for it, or that it's a priority, that it might still continue in your grant.
I'm not sure if I tracked on the piece, and if you wouldn't mind repeating it, Representative Dillon, about just repackage that around DOC taking on the pre-charge, if you will.
Because right now, DOC is funding pre-charge.
Yes, well, our grants to community-based providers allow for them to accept referrals under that status.
Yes.
Insofar as the local state's attorneys, you know, permit local law enforcement to make those referrals. So it's like entailed as a capacity. whereas we set some target numbers for what we expect to be the volume of service around the post-adjudication cases, because we see that as the direct sort of connection back to correction, that you won't see that language, in our grant. It's sort of it's capacity that is available if it's engaged. So to that extent, we fund it. I'm not sure if I'm.
So that's the piece that I feel like is tricky for us of, I'm hearing you say like you would like to be able to focus energy on post-adjudication type pieces, but yet I'm also not hearing you say, yep, in a year from now, we are not going to allow for this pre-charge capacity anymore. And that,
Yes.
I feel like, what is the word for it? Is leading people on to be like, okay, well, it's going to be there. So I'm not going to jump on the creation of this new pre-charge because
I
this
see.
is working.
Okay, right. Well, that might be referred to as a bit of a chicken and egg dynamic, and sort of like, I acknowledge that challenge, and how it might impact the perceived need to advance this.
Yeah, so I guess
So who is the person to speak to that? Is that?
I guess that, but then also my other pieces, so if DOC is potentially going to hang on to allowing for this pre-charge capacity in their grants, then I feel like I want to start having the conversations around, well, let's include some of the stuff that we're putting in here into DOC so that we're still holding the same standards, data collection, confidentiality, all of that, because this is the structure that we're saying that we want.
Mhm.
And I think you would agree that DOC is not holding that accountable to this level that we're seeing in this bill.
In the pre-charge space?
Yeah.
Yeah, we have a different, the reporting is, we don't get the individual information about those folks because, again, we don't have a statutory relationship to them. So I see the consideration that creates. I don't have anything in particular in the way of a corrections position on that in this moment. But I think the discussion is, it resonates. Yeah.
You just happen to be the person in the chair, and maybe that's a bigger problem. I don't know if that's the commissioner or like, I feel like that's the piece that we're stuck at.
Yeah, one piece that I do think is helpful, and this is a part of the farmhouse analogy. The Department of Corrections has grants that define a scope of work. Again, that's laid out in a grant. We've historically called that scope of work a community justice center, which is kind of confusing in that language and also has been utilized in various ways. But even within that scope of work, it's a mixture of funding for programs that are not statutorily prescribed. And I would offer COSA, Circles of Support and Accountability, as an example of that. Phenomenal program, great efficacy behind it. We're a leader. It's a deliverable of our providers. It's not in statute. Reparative boards are. They are statutory, they're part of the statutory architecture. The prevailing language right now requires the Department of Corrections to support a post-adjudication restorative option that we call reparative boards. And so what I can say is my statutory analysis is that anything outside of what are originally called reparative boards are funded through the discretionary power of the commissioner to award grants for the prevention of crime. There's language in the in 28 are in the powers of the commissioner. And yet we bundle that funding for services that are discretionary with one that's statutorily required. And so, so that gets, again, it's a level of complexity. And yet we want to be sensitive to the impact of what would happen if we were to retreat, if you will, or refine that scope without sort of a succession plan. And yet I understand that perhaps the incentive to create that plan isn't as imperative if there can't be a definitive statement.
Yeah, which I feel like that's where we're at. And I also feel like it's responsible government on our end, that if we're saying we want this tool to exist in Vermont and be statewide because of the positive implication it has, especially on our judiciary, then I feel like we need to make sure all things align, that either the entity that is currently funding it and overseeing it is doing that at the level that we see as important, or that we transfer it, and that it would be great if the agency could sign off of like, yes, we support it going that way. So, yeah.
And there's still there's the money issue and funding issues, because there's still the Attorney General's office does diversion. We're trying to move this into diversion, but yeah, there are different ways to get at this, but Angela.
Yeah, if I could just amplify what Karen is saying, because I think even as I conceptualize what this bill is trying to do, I would just imagine a clean handoff. I think that a clean handoff would be important for clarity and structural integrity of what this bill seeks to develop. And so, of course, there are, as Chair said, funding is a separate, equally important issue, but structurally, I've certainly always imagined that there would be a very clear delineation of oversight and support a number of ways. I'm glad you brought that because you actually helped me realize that I was just that was my working assumption, and that we haven't actually heard for certain yet that that's the position of the DOC, or so that clarity would be great.
Yeah. Yep.
Any other questions? Not seeing any. We'll take about a 10-minute break. We'll be back at 2:45. Hopefully the chief, if they're still on, can hang out with us a bit longer.